focusing, drilling down on one of the very important issues in the Convention on the Rights of Persons with Disabilities, Article 12. And we're going to have a couple different approaches and discussions to it from different countries. What I'd like to do, because time is getting away from us, is to have the questions at the end of all four presentations. So we'll make sure that everyone who is giving their presentation has the time to do that. We'll have some time at the end for questions. And so we will begin with a discussion about an approach that's being taken in Colombia by Andrea. Are you going to be up there? Oops. I got it.
That's fine. See, I'm usually not very good to stay still, so bear with me, especially because this looks like a Roman circus from here. My name is Andrea Parra, and the work I'm going to talk about, let's see, this works. I am from Colombia, and I think the previous session gave some inspiring comments, and also, as Alberto mentioned, human rights defenders is an issue. Colombia has the longest armed conflict in the world. Started in 1948. We're still at war. And it has over 7 million direct victims with a disproportionate impact in indigenous populations, Afro-Colombian populations, women, and of course people with disabilities. Many hundreds of thousands of people have acquired disabilities as a result of being the victims of the armed conflict. And as maybe some of you know, we are in peace negotiations right now. The most promising attempt so far. And unfortunately, victims with disabilities have not been direct participants of the conversations in Havana that are taking place in Havana, despite the fact that LGBTI victims, women victims, indigenous victims have been able to send delegations to Havana. So victims with disabilities have not, which is a very big concern if we are trying to build a peaceful society. And everything now in Colombia is post-conflict, even though we're not post-conflict yet. We are also, as Peru, a civil law country, but with a very strong constitutional case law presidential system that started when the constitution changed in 1991. Some of you may have heard that the Colombian Constitutional Court has issued some of the most forward-thinking human rights decisions. It's usually used in comparative law with the South African court. And some of the cases have had regional impact. They are used as a reference. We have also, because we have a civil Roman law system, we have a civil law that was created in 1887. And it also talks about the legal capacity system and substitute decision making. Unlike Peru, it states who is completely incapable, and it lists minors. It lists the word before was demented. Now it's people with absolute disability, which is an odd term to use in a law, and also deaf people who are not able to communicate, make themselves understood. That's the language that it uses. Before it said that cannot make themselves understood in writing, but the Constitutional Court declared that unconstitutional. The CRPD was ratified in 2011, and in 2009 there was a big legal capacity reform that copy-pasted the principles of the CRPD, but maintained guardianship, plenary guardianship, and created partial guardianship. So it confuses incapability with disability, the law itself. So that's also part of the context there. In 2013, Congress issued a general disability rights law and created a mandate for the Ministry of Justice and other agencies to reform legislation to align it with Article 12. Because of the armed conflict and the whole process and the peace negotiations that are happening now, in 2011, a very important law was passed, which was the Victims' Law. That became a huge priority for government, for government agenda and political agenda. So the main concern of this administration has been reparations of victims of the armed conflict and land restitution and land return. Colombia went in 10 years from being 60% rural to 60% urban because of forced displacement. We're only second to South Sudan in the number of people that are forcibly displaced and that have been forcibly displaced because of the armed conflict. Also, unlike Peru, there is widespread institutionalization and thousands of people are declared on their plenary guardianship every year. And so that's also an interesting dynamic, because even though we have different perspectives, I mean similar systems, but different impacts of the same kind of developing situation. Also, one thing that I should mention is that it's one of the most dangerous countries for human rights defenders. And there's plenty said here. The other thing is that Colombia ratifies every single human rights treaty. And regardless of which government we have, conservative or liberal, will always make statements saying, yes, we know the situation is really bad. We are working to implement human rights. And the reality is that we have good laws in paper, and the huge challenge, as in many of our countries, is implementation. So I think that the strategies that we've designed have that as a framework, because we don't want a reform in legal capacity law to just stay as one more law that are thousands every year that Congress passes. So the other thing that I should say before getting into the nitty-gritty is that my own background is on gender-based violence and sexual and reproductive rights, and on the question of how to do human rights work from an intersectional perspective. So that's kind of the lens, and I'm also a litigator. So that's kind of the lens that has filtered the way that we've done the work that I'm going to share with you today. So also this journey is a journey of many people, not of one single story. We have worked in alliance with various types of civil society actors. So with academia, mainly with two other, and the work that I'm going to talk about, I have engaged in as the director of a legal clinic at the University of Los Andes in Bogota, specifically PAIS that Eleanor mentioned earlier. And we worked in alliance with other two universities, the National University of Colombia and the Externado University. Then with DPOs, key ally organizations, the network of a network of 13 organizations of people with psychosocial disabilities, a national network of people with intellectual disabilities and their families, and also the Colombian Autism League. They have been kind of key main actors, and thanks to also some of that work, 2 years ago, a coalition like the one some of the other presenters have talked about was created that brings multiple groups of people with disabilities, and it was created with the goal of drafting the first shadow report that Colombia submitted, Colombian civil society submitted to the CRPD committee that's coming up for review this August. So it was actually a good excuse to create a democratic process of alliance and coalition work, because the disability rights movement in Colombia is very fragmented, as I'm sure many of you have experienced. It's also very militaristic, because a lot of the veterans are facing the barriers that people with disabilities face. It's very heterosexist and it's very white. So it's a complicated dynamic to address. So that's what created the Colombian Coalition for the Implementation of the CRPD, that it has national reach, and the main goal has been to draft this shadow report, but my hope is that it will continue to be a political actor in Colombian civil society work. Also, there are some international organizations that have presence in Colombia, like Handicap International, that have sponsored network and political strengthening in Colombia of organizations of people with disabilities, and we also work regionally with the Iberian American Network about the CRPD, that are legal clinics in universities in Argentina, Peru, Mexico, and Colombia. The other actors that are kind of the unlikely allies that we've worked with are very historically traditional mainstream human rights organizations, like the Colombian Commission of Jurists. It has extensive experience in international advocacy and conflict work, and we've joined forces with them. Also, for the first time, the Colombian Coalition Against Torture included issues related to violation of the rights of people with disabilities, such as forced sterilization as a form of torture. And as you can imagine, because we are in a country with an armed conflict, the concept of torture was a very traditional one: persecution by state agents or guerrilla or paramilitary groups in Colombia. So that I see as an advance. Pro Familia is the largest provider of sexual and reproductive health care in Colombia. They have clinics all over the country, and they hadn't been working with a disability rights perspective, yet they were the main agency that was asked to perform sterilization procedures on people with disabilities. So what we've been in a process, also thanks to funding by Open Society Foundations, of incorporating a disability rights perspective into the services that they provide throughout the country, which has resulted in manuals for healthcare providers and internal protocols to not intervene a person without direct consent, to not perform a sterilization without direct consent. I should say that according to the data that we asked through rights of information petitions to the Ministry of Health, there are about 500 on average sterilizations of women with disabilities per year, and much less of men. But the state doesn't have data that can tell us how many of them consented, how was the informed consent process done, how many of them were under guardianship, how many of them the guardians consented. So this has been kind of a fight, and actually this is this has been the issue that has made more visible, and that we have used to make more visible the question of legal capacity reform, because it is a question that resonates among different movements, and that media has also been very interested in. Like, what do you mean that people are forcibly sterilized? And it's kind of inconceivable for mainstream people. So that has also created a platform for discussion. And also with the National Network of Women, there has been cross-movement alliances to do international advocacy with CEDAW. So that was interesting. And then we've worked mostly with the executive branch throughout this process. Mainly the Ministry of Justice has been a big ally, but the victims unit plays a huge role in what we've been able to do in terms of reaching out to public servants and actually getting to public servants. Oh, I have 3 minutes. And this is my second slide. Okay, so I'll just leave you with the curiosity of a lot of the things that we do. What are some of the strategies that we've used? Because we are a legal clinic, we've trained more than 100 law students, that many of them, and this is my pride, are working on disability rights in different agencies, so in Congress, in the Constitutional Court, in the Supreme Court, in the Ministry of Justice, in the Ministry of Labor. And in Colombia, to get a law degree, you have to do a one-year practicum providing legal services to low-income individuals. So the main legal aid providers are universities in Colombia, which means that through this representation, we were able to identify what are some of the issues. And a lot of the cases that we have received, and over the years, it's been over 400 cases and consultations relate to guardianship and legal capacity. And because of medical doctors telling families that they should sterilize their children, or because of social security benefits, like the agencies requesting families to place them under guardianship to grant them benefits. So this is a way in which we've learned what's the legal situation specifically. In the Constitutional Court, through amici brief, as Eleanor mentioned, we've been able to make a dent in the way the court has interpreted Article 12 and the obligations of the Colombian government under the convention. Some of the cases weren't even about legal capacity, but referred to people placed under guardianship. So we used the amici to bring up the issue of legal capacity and got the Constitutional Court to actually mention what the obligation for Colombia was. We also filed a constitutional challenge. In Colombia, you don't need standing to challenge the constitutionality of a law in the abstract, so you can do this kind of filing. So we did that. And one thing that I want to mention is the Constitutional Court issued a huge decision in 2004 about the rights of people who had been forcibly displaced, and subsequently issued a series of orders regarding the rights of women who were forcibly displaced, indigenous communities, Afro-Colombian communities, and people with disabilities. With the two orders about victims of the armed conflict with disabilities, they created a big mandate for the victims unit that is in charge of the reparations to victims of the armed conflict to respect their legal capacity. Because what was happening is reparation in Colombia means they give you some money, up to $20,000 maximum. So to get that money, if you're a person with an intellectual disability, the practice was you have to be placed under guardianship so we can give you the money. And they came to the conclusion, well, we can't actually repair a right by violating another. So they actually worked with us for us to develop a protocol so they could ensure reparations of victims with intellectual disabilities without violating their legal capacity, without us having a law yet. So that's kind of been the administrative process to get there, and I'm probably out of time. But I'll say that we've done research and advocacy specifically. This is on issues related to sexual and reproductive rights, focusing on forced sterilization, but also on sex education. And Pro Familia now has a platform to provide sexual and sex education to youth with intellectual and psychosocial disabilities, and with disabilities in general, but with a focus on intellectual and psychosocial disabilities, and protocols for their own providers on how to provide accessible sexual and reproductive services. We're doing a pilot project with 24 participants to identify specific supported decision-making mechanisms in 2 communities in Bogota, and that's also supported by Open Society Foundation. And basically, that has informed their rights. Lastly, I just want to mention that we've also engaged in a lot of international advocacy. with self-advocacy in Colombia. I mentioned the shadow report with CAT, but also shadow report with CEDAW was a great experience for us, and we got CEDAW to make recommendations to Colombia about sterilization. We've also been in hearings in the Inter-American Commission of Human Rights on sexual and reproductive rights and forced sterilization, which made us bring the legal capacity issue. And we are not, well, we've done a lot of training, but we're not in Congress yet. But through this work and an alliance with the presidential program for the inclusion of people with disabilities, we're able to create a working table to draft the bill. So academia that I mentioned drafted that bill, and then the presidential program created this caucus of Congress people involved that are interested in promoting the rights of people with disabilities. So that's been like laying the ground for them to receive the law. I just want to say Congress has never been useful to advance human rights in Colombia. All the rights of all the movements have been won through constitutional litigation. LGBTI, women, indigenous communities, black communities. So Congress has always played the role of blocking them. That's why we want to be very conscious about laying the ground. And that's it.
Thank you very much. Well, we decided, for those of you who've come in late, is we're going to have the questions at the end of the 4 panel presentations to ensure that everyone gets a chance to make their statements. And we also have a revised schedule. And now we're going to hear about draft legislation on the same kind of issues from Bulgaria and Pavleta.
Yes.
Floor is yours.
Thank you. Sorry, techniques. Yes. But there's some of the things. Yeah. Okay. Okay. Thank you very much. So the name of the presentation that you cannot see obviously on this slide because some technical issues had appeared is the name of one of the pictures you saw last night in the exhibition and downstairs. A portrait of a soul. Can we make a change? So my name is Pavleta Alexieva, and at the beginning I would like to thank to the team of the Center for Law and Disability Policies for this kind invitation to us to share with you our work that is focused on Article 12 from the UNCRPD that we do in Bulgaria for 4 years till now. And I have to be in 15 minutes, right? Ready? Yes, I will try to do this. And at the beginning, I would like to share with you some feelings that I had for 2 days being with you. But standing here in front of you, I had never been in such an audience, such an international knowledge gathered in one room before. So excuse me if I'm a little bit nervous, but you're really quite a test for me. Speaking about such a sensitive issue as legal capacity for people with intellectual disabilities and psychosocial problems. And also sorry if I'm not so easy to understand sometimes. I'm a lawyer, so excuse me, I will try to speak really in an accessible way. Okay, so I had prepared a very, very long presentation for you that takes more than 40 minutes to do. But coming here, flying to Ireland, I read the memo from the first day, and I realized that most of the points that I was about to make are already covered by the previous speakers. So I will try to be informative and to present to you the next step program that is focused on piloting supported decision-making in Bulgaria and getting the results translated into legal language and formulating these results into a draft legislation that should be replacing the guardianship model. So, starting talking about the next step program in Bulgaria, first of all, you have to have a little bit of notion what is the context of for people with intellectual disabilities and psychosocial problems in Bulgaria. First of all, we had ratified the convention in 2012. We had also a little bit of backup from the international community, some key cases before the European Court of Human Rights that are helping us to motivate the government to ratify the convention. And also after that, the Council of Ministers adopted strategic policy document saying that in our legislation we should make some changes with regard to the guardianship model in order to comply with the requirements of the Article 12 from the UNCRPD. And also our courts were put in the dilemma how to deliver justice when you have in the domestic legislation guardianship and when you have a ratified international document that says that guardianship is not longer wanted in a democratic democratic state that respects human rights for all and equality before the law. We had also the ombudsman who used his right to address this issue before the Constitutional Court. Not so successful, but give us a very good notion about the attitudes of decision makers, of politicians, towards changing the systems of guardianship with something else. And also we had the role of the NGOs that I will talk about this more or less within the next step program presentation. This is just to see, this is an abstract from one of the cases before the European Court of Human Rights, Stanev versus Bulgaria, Rusi Stanev. So you can see how the European Court make this relation between guardianship system and the deprivation of liberty of people that are placed in social institutions. And this is where Rusi Stanev used to live when he filed his claim before the European Court of Human Rights, trying to sue Bulgaria for not letting him out of the social institution. He was under partial guardianship. And this is how we see it in our exhibition. As I told you yesterday, there are real stories behind each of the pictures. They are inspired by real life stories. And the status quo, what are the actual attitudes of people, how they see guardianship system in Bulgaria, you can see in these 3 bullets, very in short. Guardianship serves to replace the missing personal care for adults, and it also, the inability of the community to take care of these 2 groups of disabled people ends up in putting them in social institutions and deprivation of legal capacity to act for them. And we have a long history, more than, let's say, about 70 years of history of institutionalization. And this history actually ends up in breaking up social relationships between people and their close relatives and their communities. Well, there are some also technical problems with this slide, but I would like to read these 4 bullets for you because these are the axioms. You know, in mathematics, axiom is something that you don't need to prove. You just take it for granted. And you build your thesis on the basis of these axioms. So these axioms we use to build up our next step program. And they go like everyone, regardless of whether he or she has disability and how serious it is, has desires, preferences, and will. Desires, preferences, and will should always be recognized and respected regardless of the problems in communication. Everyone, regardless of whether he, she has a disability, is able to build relationships of trust with another person. Everyone, regardless of whether he or she has disability, at some point needs support in making decisions and receives it from people whom he or she trusts. And if you think really for yourselves, everyone is functioning in the social life in this way. We never take decisions for ourselves all alone. We always consult or seek support from those we are trustful to. And what is the next step program actually? It is first of all a partnership initiative. So it's a very good partnership between 3 or 4 organizations at the beginning. The Bulgarian Association of People with Intellectual Disabilities, and each of these organizations has a very specific role to play in this program. So in short, BAPIT, Bulgarian Association of People with Intellectual Disabilities, this is a parental organization, an association nationally based, an umbrella in Bulgaria that represents people with intellectual disabilities by their parents. The other organization is the Global Initiative in Psychiatry, SOFIA. This is the local organization of the International Network of Global Initiative in Psychiatry. This is an expert organization that is dealing with and helping, providing social support to people with psychosocial problems. And why we didn't have in this partnership an organization that represents people with intellectual disabilities, for the group of people with psychosocial disabilities, simply because this group in Bulgaria doesn't have, till now, a very strong, stable, representative organization. So we had the support of GIP. It is the Next Step program, besides that, besides the fact that it's a partnership initiative, is a pilot initiative. And what I mean that it is a combination of 3 projects, separate projects. 2 of them are pilot projects where experts in social care are trying to shape various, or to find various instruments how to provide supported decision-making and how to build up supportive decision-making measures around these 2 groups of people. And these are the so-called pilot projects. And the 3rd project is ours, of BCNL, Bulgarian Center for Not-for-Profit Law. We are a team of lawyers, and our task is to pay attention to the results that are coming from the different interventions within the pilot projects and trying to translate them into legal words. Because of this construction of the pilot, and here you can see our specific role, what we do for the pilot projects and what BCNL is actually involved in within the Next Step program. Actually, this structure of the Next Step program gives us a very good evidences before decision makers why the proposed measures that should be alternatives to guardianships are really working, because nowhere, as far as I know, there is the truth instrument that someone would say, yes, guardianship should be abolished, and this particular thing should come on its place. So in Bulgaria, we had to find our own solutions that work in our own context. For 25 years of history, of democratic history, we used to copy-paste legislation. Maybe it's something that happens in your countries too, I don't know, but it is a not so good strategy if you want to have at the end a working legislation, something that will be really implemented by the groups the legislation is dedicated to. So we didn't want it to copy-paste anything. And actually the truth is that there was not, 4 years ago, there was nothing, there is no place from where you can copy-paste even. So we were thinking how to make, how to come up with the solutions that are really working for our context. So within the pilot projects, what we do, it is, first of all, it's for people that are excluded from the community because of their disability and because they're unable, somebody thinks that they're unable to take decisions based on their will and preferences during their entire life or during some periods of their life, like in being in a mental crisis. And the pilot projects are focusing to provide support, specific kind of support to these kind of people, to take decisions in specific spheres of life. Not any kind of decision, but specific spheres of life. Those decisions that have legal consequences, not to make them decide what to eat, how to dress, and this is social functioning for the people, but decisions like where to live, with whom to live, some basic or general healthcare issues, how to be solved, what to work, how to manage my property, these kind of decisions. And actually the new formula for legal capacity to act that had appeared to us as lawyers within the pilot projects is as you see it, there are some pluses here, abilities plus supports plus accommodations equals to legal capacity for the people included in the pilot projects. And abilities are evaluated through various social interventions, and they give the answer to the team of social workers and psychologists and psychiatrists, what the person is, who is the person actually. Through the interviews with the person, based on a social central planning, the answer who I am is given to the person. And based on these abilities, the fields of life that need support, that the person needs support to take specific decisions are identified. And we combine this with some accommodations, very basic accommodations like easy to read language materials and information. And in this way, we have the new formula for legal capacity to act. But this is not stable. If you think this is not stable because we miss the legal recognition of this new formula. We need the law to say that if you have abilities, then the needed support and the reasonable accommodations by third parties, then every third party will recognize your ability to take a decision and exercise your right with your own activities, with your own will and preferences. Within our within the Next Step program, we do also some researches. So, most of them are translated into English and are available on the internet, and you might find them to see how we actually register those evidences that we bring to the decision makers and trying to convince the decision makers why guardianship should be replaced with other specific measures. And also, doing all of this, we are fighting with the huge resistance from the legal doctrine. And simply lawyers, usually legal doctrine, are saying 2,000 years of history cannot be removed like this. And you're saying that 2,000 years we are living in a lie. Also, they question the actual meaning of Article 12. And also they question the existence of women preferences for these two particular groups of people. And also we identified some serious problems that the pilot projects working in the nowadays context in Bulgaria are facing and are speeding down the results that we are waiting for. They have to compensate the lack of development in the systems, other systems like social, educational, labor system, while providing supported decision making. They had to find. At the beginning, we thought that the supported decision making instruments, the measures, are all the same for these two groups. I mean, for people with intellectual disabilities and psychosocial problems. It turned out that it is not like this. These two groups are so different from one another, and the law should take into account this and should provide various measures that will suit the needs of these two groups. And registering all the results, we came up with the draft law on physical persons and support measures. It's a piece of legislation that was elaborated within a working group in the Ministry of Justice, and my organization had participated with experts in the group, presenting the work that we've done within the Next Step program. It tries to present the paradigm shift in our legislation, challenging the traditional concept of legal capacity. And it says in one word that all people have legal capacity to act at the age of 18, and this cannot be questioned anyway, in any way by the law. It presents a mechanism to abolish a substitute decision making, the guardianship. It also provides some provisions that say there are certain types of rights, so-called personal rights, that could not be restricted in any way. I mean, exercising those rights, people cannot be evaluated whether they can take decisions or need support. And support measures should not be provided for these type of rights. We recognize these type of rights that are based, and when you exercise them, these are based on emotional decisions, not rational decisions. And these rights are like related to family life. Should I marry? Should I divorce? Should I make a will after I die? What will happen with my property? And also the law introduces the trusted relationship as an instrument to validate the support measure that should be provided to a specific person and who will be the supporter. So this is the most difficult thing in the law, and when we think of the future, if this law becomes a fact, is how you prove that there is a trusted relationship within a court procedure, and who should be involved in such a thing. So I will stop here, and just giving you the brief notion about the draft law, and the whole presentation I think will be available to you. And there is an English translation of the draft law, not the final one, but a previous one, because when you are doing advocacy, sometimes you have to make some, how to say, bargaining with the decision makers, and sometimes you have to say, okay, we can leave this aside, but let's say focused on the main things in the draft law. So I cannot tell you what the final draft law will look like. So, final conclusions. Do I have any time? Yeah. The things that I wanted to tell you is that the Next Step program is a model advocacy initiative, let's say. And in my opinion, talking to colleagues that are coming from similar legal contexts and similar historical contexts in other countries, sometimes it is useful to copy-paste legal steps, legal advocacy steps from other places that had proved to work. And there are three things that are important for me. One is that if you start to advocate for abolishment of guardianship, at least in Bulgaria, we came up with the fact that it is working only if it's a bottom-up initiative. If you have some evidence on the ground that something else will work besides guardianship. Otherwise, decision makers, it's an abstract concept, legal capacity to act, and it's very difficult to explain to people that are working in various fields. So you need some real cases, like real people saying it worked for me, and you need the proofs for this, the researches. And also it's an initiative that could not be done only by lawyers. And I think that it is true also when we talk about support measures and legal capacity to act. It's not a legal matter. I mean, the law should look at the things that are working on the ground and just translate them into words and make them stable. But there are other specialists and professions that are important in this process, and the lawyers should seek their help. Let's say it like this, like social workers, psychologists, psychiatrists, etc. And the third thing is that you have to, this is what we concluded within working on the Next Step program on advocating for abolishment of guardianship in Bulgaria, is that you will never find agents of change that are ready. I mean, you have to build up some agents of change. You have to search for open-minded decision makers, educate them, so that at the end you will have people that will speak your words, your thesis to others. So this is my conclusions to you, and thank you. Thank you for the patience.
Thank you very much, Pavleta. Remember, if you have questions, we're going to do the questions at the end, so remember your questions on the law in Bulgaria. And now we're going to move to another part of the continent, to Ireland. and we're going to hear about the new assisted decision-making law in Ireland, and we're going to hear from Eleanor again.
Hi everyone again, and thanks very much for giving me the floor. Okay, so I'm going to talk about Ireland's process of developing the Assisted Decision-Making Capacity Act. And some of you have probably heard a version of this presentation before, but for some people, I'm guessing this is the first time you've heard about our law. So on the image on the slide is of our former Minister for Disability, who is a Labour Party Member of Parliament. And this is an image, a snapshot from the committee stage debates in the Parliament on the bill. So, I'm going to tell you about the very outdated law briefly that we still have until our new act, which was passed at the end of last year, will be commenced, which we expect to happen possibly by the end of this year. We were told 6 months. It wouldn't be commenced for 6 months, but the 6 months are almost up and there's no sign of a commencement order yet, and the codes of practice are still being developed. So I'll try to give you a brief overview of the innovations in the Act and the structure in terms of who will implement it, as well as how the Act compares to Article 12 and the perspective of those of us in civil society who campaigned long and hard on this Act, and many of us are still traumatised possibly from the campaign. And I want to acknowledge those colleagues who worked so hard with me on this journey. All of the NGOs and DPOs, we had a coalition, much like the others have spoken about, but especially also the researchers who worked here in the centre with me on this, and some of them are in the room. Liz Brosnan, who's currently working with me on this process, Elizabeth Kamundia, who we were blessed to have with us working on this at an earlier stage, and other colleagues including Lucy Series, Anna Arstein-Kerslake and Piers Gooding. So, what do we currently have in our law? Well, we still have in force right now in 2016 the Regulation of Lunacy Ireland Act from 1871. So this is a very outdated system of plenary guardianship. And the only good thing I can say about it is because it's so awful, there are relatively few people who are under this form of guardianship. There's about 3,000 people in the entire country out of a population of 5 million who are currently wards of court. What we call the Committee of the Ward is a misleading term for what would in other countries be called an adult guardian. It's often just one person, but it can be more than one. And if there's no one suitable to act as the Committee of the Ward, the High Court can act as the person's guardian and make decisions. So it's a very total guardianship system. It's based on the person being declared of unsound mind and incapable of governing himself or his property. And to be honest, it was really more about property. So people who are currently wards of court are usually made wards of court because of some property they've inherited or some compensation they've been paid due to a disability that they've acquired, perhaps. So that's what we're dealing with, and we're trying to come all the way from 1871 to 2015 in one go. So, how did we do it? What do we have in the new Act? So, we have some guiding principles and we have a definition of capacity. But we have 3 new systems for either supporting people to make decisions or the final system, which is more like a substitute system of decision making. So, assisted decision making agreements are more a support measure, a very flexible measure that any person can make at the age once they turn 18. And you do not have to have any disability to make this kind of agreement, but you can make this agreement because you consider that your capacity to make decisions may be questioned by others. You choose one or more people you trust, you make the agreement with them, you register it with the Decision Support Service, which is a new office established by the Act. And then if anyone, like your lawyer or the person at the bank teller or your doctor, questions your ability to make a decision, you can produce your agreement and say, I use assistants to make decisions, this person is my assistant, and you have to respect the decision that we have reached on this issue. So it's like a safeguard, really, or a sort of backup plan if your decision making is questioned. The next step up is the co-decision-making agreement, which is a process for a more intensive kind of support. So the assistant is merely advising and the person and communicating their wishes to others. The co-decision maker is someone who is actually legally responsible jointly with the person for making certain kinds of decisions. Again, it's a person that the individual trusts and has chosen to make those kinds of decisions jointly. And there are certain kind of exclusions from both who can be a decision-making assistant and a co-decision maker. So really these are roles that are reserved for family and friends, and they're not really for, they're not allowed to be performed by professionals, by, let's say, staff from disability services or healthcare professionals. It is really a purely family and friends role, and a trusted person that will undertake these roles. The decision-making representative then is more like a guardianship arrangement. While the assistants and co-decision makers are appointed directly by the person through a written agreement that is then formally registered and do not require any sort of court process to make those agreements, the decision-making representative can only be appointed by the court, and it will be appointed when the court deems that the person lacks the mental capacity to make the decision for themselves, and there is no less restrictive way possible, that there's no assistant available to the person, there's no co-decision maker available to the person that could support them to make the decision. However, the one important way in which this is distinguished from other kinds of guardianship is that the representative is still required to make the decision that they believe respects the person's will and preferences. So unlike other forms of guardianship where guardians are acting in what they perceive to be the objective best interests of the person, here the guardian or the representative is acting based on how they interpret the person's will and preferences. So I think this is why Giorgi suggested the title for this presentation about whether our act is a compromise or too compromised. So this was a really difficult negotiation for us, and the fact that mental capacity and what we call the functional test, so being able to understand information and retain it and in order to make a decision, and understanding the consequences of your decision, is something that is used to determine whether you can have support or whether you will be forced to have a representative. So that was the big battle, I would say, that we lost. But the big battle that we won was getting rid of best interests and having respect for will and preferences in the guiding principles of the Act. And that's really, really important. I'm not going to talk about powers of attorney now due to time, but I'm happy to take questions on that. The one thing I will say about advanced healthcare directives, this was something that was added into the legislation at a later point. And they are designed, in theory, to work equally for advanced decisions about physical health and mental health. However, they are not legally binding if you are made an involuntary patient under the Mental Health Act, and that was another big loss for us in civil society. And we pushed really hard on that up until the very end of the negotiations, but ultimately we were unsuccessful. So I've already talked about the implementation structure. It will be a decision support service. Another slightly disappointing fact is that this was originally to be a new independent office under the court service, but in the very end of the negotiations of the Act, it was moved swiftly into the Mental Health Commission. And a number of us objected to this, especially because it might give the impression to the public that this service is only available in a mental health context, which is not true. But nonetheless, we could not stop it, and that is now where the decision support service will be, and I can talk more about that later. The judges who will decide cases about who should be appointed a representative will be mostly from the Circuit Court, which is our second-tier court system. They will be specialised judges, but unfortunately the specialised judges have already been appointed, and they were appointed due to their experience in personal insolvency. So the extent of their knowledge about legal capacity is something that I'm sure will need to be supported. And the High Court then has the authority to review decisions, and also certain very serious issues, including organ donation and end-of-life withdrawal of life-sustaining treatment, are reserved for the High Court. So I've talked about the definition of capacity. I've told you our most important victory in the guiding principles, which was the will and preferences, the respect for will and preferences, and removal of best interests. So you will not find the term best interests anywhere in the Act. And again, I can tell you more about these in the questions, but I think I've roughly explained the roles of the different decision makers. So how does the bill compare to the Convention, to Article 12? Well, we still have the functional assessment of mental capacity, and this was the hardest thing to try to get into the decision makers' minds about the dangers of this functional test. And we did not succeed on this ground, but we pushed to the very end. And Catherine Zappone, who you heard yesterday, was a strong advocate for us in the last sessions of the debate in the upper house of Parliament. I would still say we have a form of substitute decision-making in the representative role, even though it's not quite as bad as other forms of substitute decision-making that are based on best interests, but nonetheless, it's still a person who's appointed against your will and based on a determination that you lack mental capacity. However, at least they're supposed to do something based on will and preferences. My big concern is that there is nothing in this act for people who do not have family and friends who can act as supporters. They will end up being appointed representatives by the court, and that's a big concern. We did delete best interests, but there are still some places where the term interests remains in the act, and so we have to be very careful and monitor how that's going to be implemented. And there are certain areas that have been excluded from this act or discriminatorily treated under this act, including mental health, as I described. But there are other laws, as Catherine mentioned, on consent to sex, on voting, on jury service, that this act does not change, and those still need to be changed. So in closing our wins and losses, I never even spoke about informal decision-making, but if anyone's interested, you can ask me about it later. We managed to remove this whole part from the Act. It was going to provide for a system for anyone, third parties, to assess someone's capacity and decide that they lacked it and make a decision for them, and we managed to remove that. But that is something as a sort of a general defence that exists in the Mental Capacity Act in England and Wales, for example, and many other laws, and we were able to delete that, so that was great. We made some wins on legal aid and on the assistance provisions, and we were able to tighten up some of the rules about co-decision makers. But we lost on the functional test, we lost on the advanced healthcare directives, and the decision support service, despite our best efforts, will be in the Mental Health Commission. So I'll end there, and I'm happy to have reflections and discussions with others about similar processes that they're engaged in. Thank you.
Thank you, Eleanor. You can see that we're going to go beyond our even revised schedule, so we're going to give Giorgi and Tamuna a chance to describe the issue of what's going on in
Thank you. I will be very short. I don't have a long presentation. Actually, it's going to be only me, I guess. But I will still need Giorgi and our lawyers to be closer to me, because I'm not a lawyer and I'm really afraid not to make any serious mistakes. And so please, I'm asking my colleagues to correct me as soon as I hear something, I don't know, wrong. We were asked to talk about the historical decision that our Constitutional Court made in October 2014. Like I said, we ratified the UN Convention in December 2013. It was enacted in April 2014, and some of the processes in terms of implementing the CRPD are very slow in Georgia, like designating focal point for and coordination mechanism for CRPD implementation, but other processes are quite quick, like this recent Constitutional Court ruling that we had in October 2014. So it was. We are not afraid to use the word historical, because it is really historical how the court reviewed and what kind of arguments they used and how they described their reasoning and what's the other word? Sorry. Reasoning and operating part of the decision. Sorry about that. So the Constitutional Court deemed all of the aspects of legal capacity as unconstitutional and ruled for all persons with disabilities to enjoy their legal capacity. And the legislative amendments that followed the Constitutional Court ruling were even more progressive, and they established even more higher human rights standards, and I will talk about those later. Before we had thousands of people, we still do. We have thousands of people who did not have legal capacity, whose parents or family members or friends were their guardians. As for those who were in the institutions, their guardians, state representatives like social workers or staff persons of the institutions were their guardians, and all of their they could not access services because of having no legal capacity. They could not go to school. They could not go to try to find a job. They could not vote. So they were deprived of all the rights that the Constitution of Georgia grants citizens of Georgia. Our lawyers, at least our lawyers, tell me that the Constitutional Court ruling changed the legal theories in Georgia. So this recent ruling. So there was never been in Georgia such an understanding and such an in-depth debates about the legal capacity of persons with disabilities like we have now after this ruling. The law students and law departments of universities are very intensely discussing and debating around this decision. Universities are organizing conferences on legal capacity and on this Constitutional Court ruling. In fact, when we were at the university talking to a law professor a couple of weeks ago, we were just talking in a hallway, and some passersby, students and professors, as soon as they heard the word legal capacity and Constitutional Court ruling, they gathered around us to listen to the interest in discussion, as they put it. So this Constitutional Court ruling has really triggered a lot of attention and a lot of the in-depth understanding of the rights of persons with disabilities. So besides that, the Constitutional Court ruling, what it did, it led the reform in legal capacity in a healthy way, to say so, because the demand to recover legal capacity for people with disabilities came from the legally incapacitated persons themselves. They approached the court with the demand to examine some of the concepts or all of the aspects of legal capacity in their relation with their constitutionality, and the Constitutional Court, in the end, it took them 2 years to review and to examine the claim. In the interviews, the judges describe how hard it was for them to actually challenge the prejudices and stereotypes they had inside themselves before they came to this decision. They also, the biggest challenge as they described it, they had was giving the right to persons with psychosocial needs to the right to marriage and to family life. But in the end, they also decided in favor of this, and they said that all persons with disabilities, they ruled that all persons with disabilities should be able to enjoy their legal capacity. What followed after that is that the Constitutional Court gave 4 months time to the Parliament of Georgia to come up, to develop legal amendments for a number of laws and legal acts. Initially, and the Parliament adopted new legislation in April 2015. So, excuse me. So initially, the Parliament of Georgia prepared legal amendments for 33 laws, including Civil Code and Procedural Code of Georgia, and lots of other legal acts and regulations. And it was really quick. So they respected the deadline that the Constitutional Court gave to them, and in 4 months' time, we had completely revised. Not all of the legal acts. It's still ongoing. The Parliament is regularly adding more and more amendments in more and more legal documents. I think by now we have 61 documents revised already in line with the Constitutional Court ruling, and it's still ongoing. So the Constitutional Court deemed depriving persons with disabilities of their legal capacity as unconstitutional, according to the following articles of our Constitution. For example, everyone is free by birth and is equal before law, regardless of race, color, language, religion, political or other opinions. Article 16, everyone has the right to free development of his or her personality. Article 17, honor and dignity of an individual is inviolable. Article 19, liberty of an individual is inviolable. Article 24, everyone has the right to freely receive and impart information, to express and impart his or her opinion orally, in writing, or in any other means. And Article 42, everyone has the right to apply to a court for the protection of his or her rights and freedoms. So the ruling of the court reflected upon the constitutionality of depriving persons with disabilities of their legal capacity exactly in the context of the rights that are guaranteed in our constitution for the citizens of Georgia. So, but while the operative part of the ruling is undoubtedly very progressive, everyone agrees about that, there are some criticisms towards the reasoning part of the constitutional ruling. Mostly arguing, there are arguments that the court did not really elaborate on the absoluteness of these rights. In other words, they did not really stress legal capacity as an absolute category of rights. And in fact, the court allowed for the full deprivation of legal capacity only in one case, when due to medical reasons the person is unable to communicate with the outer world in any means whatsoever. So there are the legislation that followed and the legal reform that followed the constitutional court ruling. Like I said, it's very progressive and it goes even beyond the constitutional ruling, but the practical side of implementing the legal reform is questionable, to say so. There is the barriers implementing the legal capacity reform start from the very beginning. So even though the parliament said that all persons with disabilities formally announced as legally incapacitated have the right to apply to the courts to be released from guardianship, we have had a case when the court did not process the claim of one person who was asking to recover his legal capacity. Also, we asked for the information on existing legal capacity cases from the courts on the recent cases, and we see an increasing trend of judges ignoring the constitutional court judgments and their reasoning, and really approaching these cases in a very similar, identical manner. The judges, which means that they are misreading the constitutional court ruling as well as misleading the implementation of the legal reform itself. Their approaches are, it shows that there are no individual assessments done, no individual approach taken, and the courts, when asked about this, the judges say that they are limited with the claims of persons with disabilities themselves, how they put their claims, and also they're limited with the examinations and conclusions issued by the State Medical Expertise Bureau. And here I would say, I want to say a few words about the role of this bureau. It's a state agency which was tasked by the Parliament of Georgia to assess persons with psychosocial needs who might need support, and to develop reports upon which the judge then decides in which areas of life this person might need support. And the psychiatrists and the professionals at this expertise bureau are the weakest, the weakest ring in this chain, to say so. This is a group of 4 professionals: therapists, psychologists, psychiatrists, occupational therapists, psychologists, psychiatrists, and a social worker. And they have been. It is always also hard for them, like many other people in Georgia, to overcome the Soviet legacy of viewing disability and viewing persons with psychosocial needs as full citizens, having their desires and rights and their plans for life. And so they are mainly, when doing their assessments, they're mainly just dismissing these people as needing support in almost all areas of life. Like we've seen court decisions which lists, which says that this person needs a supporter in religious issues, or in voting, in expressing their opinions. So and the judges are I don't know, using the conclusions of the expertise bureau as a foundation for their decisions, which means that the expertise bureau is not really doing their job greatly. So it's the weakest part of implementing this reform, we would say. Well, however, we were not expecting that, as unprepared as we were for this very progressive and very historical constitutional court ruling. We did not really expect that everything would go so ideally, and we were prepared for that. And the good thing is that members of government and parliament who pushed for this reform in the parliament and who are very supportive and cooperative. They are not going. They don't want to stop at this achievement. They're working with the civil society organizations very actively and brainstorming solutions how to address these gaps. And we are and civil society organizations and the government is having frequent workshops and meetings and studying models of different countries. And I think Ireland's experience may help us with that, how to tackle these practical gaps we have in implementing the reform. Also, one of the things is that there are gaps in the institutional institutional understanding of what supporter means. The legislation does not really clearly define the roles and responsibilities and accountability of supporters, and we are afraid that we may end up in a situation where a supported decision maker is just another word for a guardian, and we really have to be careful for this not to happen. Also, there is social workers are also at the forefront of helping persons with disabilities to recover their legal capacity, and the knowledge of social workers and understanding of disability issues is, in many cases, very low. Sometimes they confuse the concept of personal assistant with a supported decision maker. Sometimes they think that a person with psychosocial disability or a person with any kind of disability is automatically legally incapacitated. So they confuse these kind of concepts and understandings very often. But like I said, we did not expect that everything would go smoothly, and we're prepared and we're working actively. With what we knew is that until we started implementing it in practice, we would not really know what kind of barriers and obstacles we would face. Now that we've started, we've had court cases, and we've started recovering legal capacity for these people and started assigning supporters for them. That's where we see, now we can see clearly where the problems are and what we need to do in the first place to make this reform work. Actually, it's all of what I wanted to say. We have a running case on legal capacity, which I talked about during the previous presentation. This client of ours often says, I think he has it on his backpack or Facebook profile, I don't know. He says he's not going to rest until he gets his rights back, and he's ready to challenge everyone to have his rights back. So that's our kind of motto too as well. We don't want to stop and we don't want to rest until all people with disabilities in Georgia have their rights back, especially those who were experiencing civil deaths before we had this legal reform. So that's a brief explanation of the Constitutional Court ruling that we did, that happened in Georgia. There are a lot more to talk about practical side of things, and I'm ready to answer your questions if you have some. Thank you.
Thank you I'm sorry that we don't have more time for this panel because it's an amazing assemblage of expertise on this issue, which is, and we're just scratching the surface today, but we've extended the time a little bit and we have time for a few questions. So let's see, yes, right here, the gentleman from India.
I want to seek a little bit of clarification in relation to the right to be sued and to sue in case in relation to assistive decision making and co-decision making, because once you have legal capacity, then there are contractual obligations and also perhaps criminal liabilities which a person with disability, mental disability, will have to deal with. Thank you.
Yeah. Okay. Great. So this is something that we're still struggling with, about litigation capacity, as we would call it, and so the right to instruct a lawyer and to pursue a case before the court. So in this transition period to the new system, there already the bodies of practicing lawyers are revising their codes of practice to ensure that they can represent people who would previously have been deemed to have been of unsound mind and not capable of instructing a lawyer. So we are transitioning to that. But I should say that if you are using an assisted decision-making agreement or a co-decision-making agreement, you still retain legal capacity, you still retain full legal capacity. You're just using a support mechanism. So it's only on the decision-making representative role where you lose part of your legal capacity. And even there's an automatic entitlement to legal aid in those proceedings so that you can try to argue that you should retain legal capacity.
Other questions? Diana and the gentleman there. Go ahead. Yeah, and then you can give me next.
Thank you. Really interesting. One question I have actually was, and I'm going to forget your name, Pavleta? Pavleta. Pavleta, you said something at the end of your presentation, which I'm not sure you meant, but I wanted to ask you about it, which was about similar jurisdictions copy-pasting sort of the law, the changes to the law. And I have some concern about that because I feel like if you don't have a movement of people with disabilities who have themselves contributed to the legal changes in their jurisdiction, you will end up in a situation where people with disabilities don't know what the law is, they don't back the changes in the law, and they don't understand what their rights are. And so we very much always support law changes coming from the bottom up, where people with disabilities themselves have come into coalition, maybe with lawyers and with legal aid, as professionals on tap, but not on top, so that there is a community demand and a community awareness and a community understanding of what the changes are going to be. So I just wanted to put that out there, and I wanted to know if I understood you correctly.
Actually, I wanted to make, this is what you said. This is why I said that our experience, 25 years of modern democracy, when you make laws for a country that wants to make a very huge jump to go for other more developed countries, the easiest way is to copy-paste other legislations, just to translate it in native language and put it in the legislation. But after that, you end up with a dead law. Nobody implements the law. This is why I said that in the conclusions, that it is important to have a bottom-up initiative that involves others than lawyers. That lawyers are the last that will come in the picture. This is what I meant. This is why the Next Step program is built on the partnership between organizations of people with disabilities and our team, legal team. This is why it's so valuable for us, because it brings bottom-up evidences that these instruments are really working in real life. Yeah.
Thank you very much. My question relates to the presenter on the Irish legal capacity. We have in civil law a tradition known as the insanity defense, or an objection that the person cannot appreciate the consequence of his actions. These are the defense that comes while entering into contract or being engaged in any civil matters. So while changing this legal capacity in your legal system, have you deal with also this kind of objections that would follow? And what is the status of this insanity defense also in civil matters? In relation to that is like, what is the situation in Irish, for example? Do people have confidence to deal or enter into any legal action, into anything that will have legal consequence? Thank you very much.
Great, thanks. Really important questions. I should have also said that this Assisted Decision-Making Act is only applicable to the civil law context, and so it doesn't address issues of criminal law. And we do still have an insanity defence and also the determination that a person is unfit to plead in the context of a criminal trial. And those are two aspects of our law that we are still pushing to change, and there is absolutely no political will to change those. So that's a challenge. But I think you can make good arguments and strong arguments for changing those, and there's some really amazing projects around the world. There's a project in Melbourne that my colleague there, Anna Erskine-Kerslake, and my former colleague Piers Gooding are working on to demonstrate that we don't need these unfitness to plead tests, and that actually people can go to trial if the right supports are put in place. And also to demonstrate that you can, within the concept of intention or guilt in the criminal law, the mens rea as we would call it, so the intention part of the crime, you can demonstrate without the insanity defence that if someone really had no idea what they were doing, they will not have meet that intention requirement. So it's possible to use those mechanisms in the existing criminal law without having a separate discriminatory track for people with disabilities. In terms of inability to contract or enter into legal relationships, you're asking, do third parties, are they confident to contract with people with disabilities, or do they fear that the contract will be undone because the person will later be declared to lack capacity? I think that is an issue, particularly I would say maybe on the private rental market, where landlords might be unwilling to rent to tenants with certain kinds of disabilities, where they would fear that the contract will be overturned. And I think that's why having an assistance or support measure in place will give confidence to third parties that they can respect the decision, that they know that this action will be deemed to be legally binding. But also I think we need to have a liability protection for third parties who in good faith respect the decision that is reached through this support agreement, so that they will have the kind of confidence you talk about when they enter into legal relationships with people with disabilities.
We have time for one more question.
Hello, thank you to all of you for your very interesting presentation. I have a question for Pavleta Alexieva, sorry if I mistake with your name. You told us that in your projects there is a collaboration with organization of parents and self-advocates with intellectual disabilities. I'm very interested by this question. According to you, what are the main keys for a successful and healthy collaboration with parents as supporters, no less, no more, and self-advocates with intellectual disabilities in full control? Thank you.
Okay, a little bit of explanation for the stage that we are in Bulgaria regarding to self-advocates. We're actually now starting to identify such self-advocates when we talk about people with intellectual disabilities. So we don't have a very long history, and Eleanor had met one, and maybe there are no more than 10 self-advocates, I mean people with intellectual disabilities that can freely stand up and say what they think. And this organization that we are partner to, the Bulgarian Association for People with Intellectual Disabilities, it's a parental organization. And it is actually investing a lot of efforts in building a self-advocate network right now. And we are right now in a process but we want to give them some time to feel strong, to feel comfortable, to stand up in front of such an audience and say what they think about, for example, being put under guardianship and whatsoever. So our experience working with parents when we talk about guardianship is controversial. There are parents that are sharing the views of course, their parents, and sharing the views of a protective, paternalistic attitude towards their grown-up children. And it's very hard to overcome such attitudes, because when you're living in a system, social system that is not providing any kind of easy ways to integrate these people into the community or to make the life for them easy, more easy. So the parents are starting to be overprotective. And I will remember one discussion in Bulgaria. It was recently in March this year in a town in northern Bulgaria. One MP, inspired by the exhibition that you saw, decided to organize a regional discussion in her voting region, in the region that she was elected from, and invited parents, invited mayors, invited some local decision makers, and also organizations of people with disabilities. And most of the audience was not prepared to, to participate, to discuss the topic of guardianship. So you need a lot of discussions and to start with small steps to convince others that this is not the correct approach to providing protection for people with these intellectual disabilities or psychosocial problems, because guardianship is usually seen as a protective mechanism. It's not a mechanism that should restrain people, like physically restrain. So she invited them, and there was the Deputy Minister of Justice who was presenting the draft law. And there was me and my colleague that we are presenting the Next Step program and how the measures seen in the draft law, where they come from. And also we have a mother of a person with intellectual disability that was behind us and saying why, to other mothers in the audience, why the guardianship should be changed. But not all of them were participating from the very beginning of the debate 4 years ago. There was one lady, one mother, it was the first event for her, hearing about that guardianship is not a good system for her child, and she had already put her young child, 30 years old, was her daughter, under guardianship, and she was really frustrated by the fact that we are saying. And at the end, actually, for 2 hours of a discussion with her, at the end, she really understood what we are saying, that we are not blaming people. This is what the law provides as the only instrument for you right now. But we are saying that we can improve this, and we can change it with something better. So, working with parents is controversial. This is what I can tell you. It takes a lot of courage.
Okay, very quickly. And I just want to ask a very last question about the impact of some important case, such as Stanev versus Bulgaria, maybe on the state of mind of organization of parents about the question of institutionalization. Just on this question, I come from France, if you didn't notice my very strong French accent. And in our country, the organization of parents took the monopoly around the debates of institutionalization, and they completely changed the nature of this debate. And now it's not how to move people out from institution in community living services, it's how to improve institutions. It's the main question in France, so it's extremely controversial. It's not only a question where policymakers say that institutions are a good thing, but even civil society with extreme powerful organization of parents. So I just want to know what has been the impact of Stanev versus Bulgaria or other controversial judgments with organization of parents. Thank you.
Yeah, about the institutionalization of adults, the process is just starting in Bulgaria right now. I mean, the discussions on the process had just started. We don't have a clear plan how to do this. The thing that I can tell you about having social institutions and trying to change the guardianship system and to replace it with supported decision making, one of the conclusions that we made based on the Next Step program is that if you cannot achieve the desired results for the people while they are living in a social institution through supported decision making. They should be prepared. I mean, there should be a period when they are not living in an institution in order and to start slowly improving their social functionality and to end up with providing support measures when we talk about decisions with legal consequences. I mean, if you are not socially prepared, you cannot, we cannot have, at least in Bulgaria, we cannot have the results that we want to achieve through the supported decision making for these people. So institutions, social institutions and supported decision making in Bulgaria cannot be combined. I mean, you cannot have people living in social institutions with support measures. It won't work. It will turn up to be just a guardianship system with another name.
I don't want to take the time from this discussion, but I can describe to you some side conversation. What's happened? We had that issue in the United States, but it has turned around. But it is. We don't believe in the United States that you can make an institution better. We've tried. It doesn't work. It's still an institution. People are still denied their opportunities and their choices. That said, the next thing that's going to happen is a group photo. Yes, give them applause. I'd like everyone to go, I'm hoping it's not raining out, to the patio, and we're going to have a group photo, then we're going to have coffee and tea, and come back here at 4:15.